Today we are extremely grateful and lucky to have Mr. Jeevan Ballav Panda. Jeevan sir is a partner in dispute resolution and employment labor benefits practice in Khaitan and Co. He has over 12 years of experience on commercial and civil dispute resolution. And today's theme of the interview is combined power of youth and skills for dispute resolution. And thank you so much for joining, sir. We're extremely grateful to have you.
Thank you, Shreyas, and thank you, YCM, for having me. It is indeed my pleasure and privilege to participate and contribute to a great initiative. Thank you.
Thank you so much, sir. Sir, I would firstly like to ask you, and begin the interview by asking you that whether there is one experience or any sort of big learning that you have had in your dispute resolution practice that you would like to share with us.
Thank you, Shreyas, for the question. In fact, I would say that there has been a significant change in the manner in which we perceive disputes lawyers since the time I started my career and how we see and perceive it today. So the role of a disputes lawyer has always been that of a friend, philosopher, and guide to a client, but it has become all the more significant in view of the fact that there is a lot of hand-holding that takes place right from the pre-litigation, the strategy level, and till the final outcome of the proceeding, whether it's the execution or an amicable settlement by which the matter is brought to its logical conclusion. So therefore, one significant thing which I have learned over the years is that you have to be flexible and cannot be rigid. So you have to be flexible both in terms of strategy, in terms of your advice to client, as also the approach in particular to the matter in hand. So it entirely depends on the risk appetite of the client. Secondly, the merits of the matter, and third is the approach of a client. In many a times they are keen on a compromise or a settlement, amicable settlement, by making a cost benefit analysis. But we also handle clients who are very aggressive in terms of the disputes, and they are very keen on pursuing a dispute rather than having any form of discussion for an amicable settlement. So therefore, this is something which I have learned over the years, that one has to be very flexible in terms of approach, strategy, and the dispute itself.
Yes, sir. Thank you so much, sir. And sir, and I think that what you have said, I think, leads to another interesting follow-up question also that we have, is that, sir, as a successful dispute resolution lawyer, how do you deal with these clients who are kind of conditioned in this extremely adversarial way of dispute resolution, and they don't want to opt for a win-win solution, but they just want to fight it out either in the court or opt for litigation? So how do you deal with clients like these, and even the counsel of the other side, to come up with an amicable win-win solution?
In fact, to answer your question, I would again fall back on the first question, that the client is the king ultimately. So you can't, you can facilitate, you can advise them with the best strategy forward, but at the same time, you cannot impose upon them your thoughts or your views in particular. If you do that, and if you are insistent, then you might risk the chance of losing the client as well, because there is enough and more competition in the market. So keeping that in the back of your mind, one has to be very pragmatic in the approach, and give a very result-oriented solution, and pros and cons be highlighted. If I may use the word SWOT analysis, which we often use from management terminology. So the strength, weaknesses, threats, and the opportunities are to be highlighted to the client. And then you leave the decision making to the management, and the best decision of the management of the company or the particular client that you are dealing with. So if a client is very adamant and very aggressive about it, you cannot be insistent upon going for an amicable resolution, because it gives a very wrong message and wrong signal to the client, and they may think that you are a defensive lawyer, and that may be counterproductive. both in terms of your interest, the firm with whom you are working in case you are associated with the firm, and also from the perspective of the client, because ultimately the legal team would be accountable to the senior management of the company, and they would get an impression that you are not confident enough. So there has to be a good balance of the pragmatic approach, as also the legal and the strength and weaknesses be assessed appropriately. So that is how we approach, and depending on the final decision of the client, of course, you can work out the strategy as to going aggressive, going defensive, or being preemptive about things. About in some cases, if I may give an example, like filing a caveat, it's often perceived as a double-edged sword, because you have to, except for the Supreme Court, you have to mandatorily serve a copy of the caveat on the counterparty. So if the other party is keen on an amicable settlement, it may irk the other side, and they may take it on their, if I may use the word, commercial ego, and it may become very counterproductive, and any chance of an amicable settlement will be ruled out. So one has to decide accordingly, depending on the situation, depending on your opponent, who is representing them. So multiple factors, like any other strategy in litigation.
Yes, sir. Thank you, sir. Sir, so you also mentioned something about this commercial ego. And
Yes.
so we at YCM usually focus on interpersonal disputes and conflicts that happen between people. And there's a lot of emotions involved in that. And people sometimes tend to be more irrational and just, don't opt for a win-win solution. So, sir, that brings on to my next question is whether, to what extent is an interpersonal dispute among maybe two people different from commercial disputes? Are people more rational and logical in a commercial dispute, or is it similar? And how different are these disputes?
In fact, it's a very relevant and interesting question when you are talking from a dispute lawyer standpoint. The reason why I say that is that the term which I used, commercial ego, is something which is also present amongst so commercial entities, or like entities who are like two big multinationals. If they are in a dispute situation or in a conflict situation, they may have commercial egos of their own. So it is not that there is this human touch is only applicable in case of interpersonal disputes. In many a times we have seen that the stature of the company and the reputation is something which is the subject matter of consideration many a times, more than the commercial stakes involved in the matter. Similarly, if you are talking about an interpersonal relationship, we are talking about a divorce matter, for example, if I may give, a husband and wife. Most of the time, the dispute, a contested divorce matter, goes on for the simple reason that neither party is ready to compromise or like take a step forward. And it is mostly because 90% of the time it is the egos which are playing in their minds, and which clouds their mind in such a way that prevents them from going for a practical solution, which may be, in most cases where it has irretrievably been broken down, a amicable consensual divorce, which is also in the interest of both parties, that they can move on. And if there is a kid involved, then obviously the interest of the kid can be factored in while taking that consensual divorce. So this interpersonal relationship, while the factor of emotion comes in, and ego being is much more significant, but I would say that the even commercial entities, they are not completely not giving a consideration to a ego or a human touch, so to say, for deciding whether to pursue or not to pursue a dispute.
Yes, sir. Yes, sir. Thank you so much, sir. And sir, now I would like to bring the interview to something that is the highlight of 2020. Of course, is this growth of online dispute resolution. Sir, so how was your experience of suddenly shifting into online dispute resolution? And were you was the practice of online dispute resolution done before COVID? And sir, further, were there any problems that you've had with dealing with conducting online dispute resolutions, and how did you curb those problems?
Yes, in fact, it has been challenging times, unprecedented times, as people are calling it a black swan event. So we are in unprecedented times, no doubt about that. And the litigation practice, whether from an individual's perspective or from a disputes lawyer in a law firm's perspective, it is no different, and it has impacted each and every sector, and the legal sector is no exception. So, particularly, I would share my own personal experience that the initial part of it was very difficult in the sense we were mostly confined to advisory mandates, and with the courts not functioning and with the lockdowns and social distancing measures being in place, it was very difficult to adopt and adapt to technology. And typically, if you see, even in a law firm setup, you find that the corporate lawyers are much more technologically equipped with like softwares to help them with the drafting and also for vetting agreements, grammatical errors, etc. And we as disputes lawyer are always slow and always the last to adopt technology. But it has been indeed a pleasant surprise in terms of how courts, as also we as disputes lawyers, have adopted and adapted technology, and so quickly, because in normal times we would have never embraced this particular change. And in fact, we were pushed to the corner. We were left with no option but to adopt and adapt it fast. And that was a great significant change. The positives, if I may highlight, is that of course it has made us more efficient, and the travel time, or for that matter, waiting in courts, that is more productively utilized by sitting and researching or working on another matter. Secondly, from a client's perspective, significant savings on cost and expenses, because if I were to travel to a matter in Bombay, for example, then that cost of travel, accommodation, etc., those expenses have been saved. Sitting here, I can attend a matter in the Delhi High Court, in the Supreme Court, some tribunal, and also in a Madras High Court. So that's the major advantage. So that is the positive, but at the same time, the negative, if I may say, not a negative, but obviously it's a challenging situation when we are talking about dispensation of justice at the grassroots level. We know the courts are overburdened, but this adoption and adaptation to technology has primarily been confined to the constitutional courts and the Supreme Court, the major high courts, and some of the tribunals at the national level. At the lower court, except for the tier one cities or the metros, it's hard to find whether they have been able to, or even if adopted, whether it has been effectively utilized for reduction in the burden of courts. So that is something the percolating to the grassroots level is difficult with the kind of people, the kind of litigants that we deal with, and even for that matter, there were some reports in few months back with the Bar Council coming up with reports that even 90% of the judges are not equipped and the lawyers are not equipped. So we are talking about litigants from villages who don't even use mobile phones today, forget about smartphones. So keeping all these things in mind, so it has been a mixed thing, and maybe from a metro or a tier one city, of course, it has been a great initiative, and we were left with no option. And but at the grassroots level, still, I would say that there is a long way to go.
Yes, sir. And I also recently read that the field of the lawyers are the most reluctant to change and to technology, sir. And now that we know that it's just been practiced in the Supreme Courts and top tier courts in lower courts that also in of top tier cities, and it was a sudden change that we were kind of compelled to do because of the pandemic, sir. So do you think that this practice of online dispute resolution in India will still be followed post COVID, or do you think once things are back to normal, we'll go back to what we were and forget about online dispute resolution altogether?
In fact, a couple of days back, there has been a development in the sense that the Delhi High Court has increased the capacity of the courts functioning physically. That is pursuant to a lot of representations and submissions made by lawyers community to initiate the physical functioning of courts. While there is another section which is opposing vehemently, but there has been direction to increase the capacity by 50%. So having said that, like I would not mind having a hybrid system even after the pandemic situation. If we have a hybrid system wherein we have the low stake matters, or for that matter those matters which does not involve so much of the technical skills, if I may say, and which can be decided merely on submissions and with limited number of oral pleadings. In those cases, like for example, electricity matters, electricity disputes like pilferage of electricity, connection disputes, insurance claims, etc., or for that matter, consumer matters, which may not require a witness action. So merely on the basis of written pleadings and written submissions with very minimal oral submissions can be decided. Those can, in my view, continue with the ODR system, and also the procedural steps in respect of, say, an arbitration proceeding. The procedural hearings, instead of having a physical hearing, those can always be held virtually. But of course, there has to be a hybrid system, is what, in my view, the right way to go. But considering the dependency on the physical functioning, and again, as I would say that disputes lawyer are typically slow in adopting technology, and they would not like to move out of a court ecosystem. So that is something, that is the reason why we see so much of reluctance. And at the same time, from a individual lawyer who is earning his or her bread and butter from day-to-day appearances, which have been significantly impacted. So from their perspective, they are right that until and unless the physical functioning resumes, it's major impact on their commercial, like in their earnings, or for that their day-to-day living expenses. So therefore, the reluctance to continue with the virtual functioning. So in my view, a hybrid functioning is the way to go. Of course, it's a great initiative, ODR, and it's the way to go for, as I said, those kind of disputes which can be handled even without a physical hearing.
Yes, sir. Sir, I'd also like to ask you about. So you mentioned that in the Supreme Courts and in certain tribunals, there is an online dispute resolution system going on. So if you would have to talk about the effectiveness of the online dispute resolution being conducted there, how has that been going? Is it working well? And what should be done to improve these systems in the courts?
See, all these courts have adopted reputed like companies which are providing the platform or the technology. So to that extent, there are no issues. Of course, like there have been issues like some basic decency. Initially, we saw a lot of news reports about people not being in uniform, or for that matter, they had switched on the video and carrying out in their shorts. They are sitting in shorts, and the basic decorum of a court, those were getting hampered. But gradually, slow and steadily, the lawyers also understood how it's functioning, and because it was a new thing for everyone, so it took some time. But yes, it has done well. Rather than not having any hearings at all, they have done a great job in terms of disposing of matters even during this pandemic. And in fact, there were the figures and statistics of the number of matters being disposed of by the Supreme Court itself, particularly when some matters were being heard out. And during this lockdown period, and also during this entire pandemic situation, the number of matters which have been disposed of is quite significant. So, which shows that it's not impossible to like dispose of matters or hear matters through virtual platform. So, therefore, it has worked very well, I would say. But at the same time, there are challenges to it. So, for example, if I may say from our own team's personal experience, that the teamwork which we typically have in handling of a litigation. For example, if a senior is leading you, and you have the in a physical court, you have the advantage of prompting a senior, or passing on a slip of paper if the senior has missed out on addressing a particular point. So that is something which is missing, and that body language reading of the court, that is something which goes a long way as to how the the particular court is receptive or is not receptive to the submission. So accordingly, on the feet, you can make your own strategy. So that is something which was missing. But at the same time, the positive, I would say that you are not undermined if a junior lawyer intends to, is well read and well prepared, wants to address a court, you get addressed by your surname or your name by the judge, because your name is appearing in the on the screen. So that is something in a physical court possibly would not have been possible. The judge would address you as Mr. Counsel or any other junior lawyer. But if you are well prepared, then you get that undivided attention of the judge. So that is something from a young lawyer's perspective. I would say that that is a great thing, being addressed by a judge, and if you are well prepared. So the senior junior demarcation, that is to a lot extent is diminished. So which is a great thing.
Yes, sir. And sir, now I would like to ask you about mediation. And sir, I would like to ask you, as per your experience, why is mediation not being used to its potential in India?
The primary reason I would like to refer to one of the recent speeches given by our Honorable the Chief Justice of India, Justice Bobde, when he was speaking at one of the events recently, few months back, when he remarked that ADR is always considered secondary to litigation in India. So that is where it is. The problem is that we have always considered it as a second tier for so far as dispute resolution is concerned. It has never been considered as a primary mode of dispute settlement. So that mindset has to change. So that is where the problem lies. And ADR is often used to be considered. At least there has been a significant change when we are talking about arbitration. But again, arbitration it's an ADR form, but at the same time it is still adversarial to a lot extent. So having said that, we are making change and change for the good. Like I'll give you an example. The way arbitration was being perceived when I started my career, it was always considered to be a high tea meeting at the client's expense and after the court hours, and they were reluctant to have arbitration hearings overlapping with court timings. But after the 2015 amendment in particular, the perception about arbitration has changed. It's hardly that you find any commercial contract without an arbitration clause. And many a times, there are condition precedent of negotiation and mediation or a conciliation as a precondition to invocation of arbitration. Most of the arbitration clauses these days you will find. So that shows the change in mindset and the approach in which the litigants are pursuing ADR as a better form of dispute resolution mechanism as compared to litigation. And it took several years. When we are talking about arbitration, again taking that example, if you talk about the 1940 Act, there was a lot of judicial interference. That was to a lot extent curbed in the 1996 Act, and since then we have only been making positive steps forward. Like the 2015 amendment brought in a lot of discipline in terms of timelines, introducing timelines for disposal of arbitration. That was that, according to me, is one of the most significant changes to the arbitration law. With that came a lot of discipline, a lot of sincerity, both in the minds of the arbitrators, the litigants, and also lawyers in how they perceive. You have full day arbitration meetings, even fixed by the arbitrators, even on court hearing, court working days. And they are not willing to give any accommodation, even if a lawyer prays that I have matters in court. The arbitrators are very blunt and saying that you will have to attend the arbitration, and or else you will have to pick and choose between the court matter or the arbitration. You can't have both, and we won't be fixing arbitration only after the court hours. So that perception has changed. So similarly, if I may draw the analogy from arbitration, it took several years, as I said, in fact several decades, for the perception to change, and we have made some progress, if I may say, in 2021. Similarly, mediation, it will take its own sweet time, but at the same time, again, quoting Justice Sikri when in one of his judgments just before retirement, he said that it's high time that we have an Indian Mediation Act to bring in seriousness about how people perceive mediation. It's not that there are no statutory provisions, but in my experience, I have seen that court facilitated mediation or conciliation are given much more seriousness as compared to like ad hoc mediation directly being referred to by the parties. They consider it as a tick in the box before going into the mainstream dispute resolution, whether in the form of arbitration or in the form of a litigation. So that perception and mindset has to change, is what my view is.
Yes, sir. And sir, so continuing our discussion in terms of how we need to bring a change in the mindset of citizens in terms of mediation. So, do you think that maybe the youth can bring a change in our country's dispute resolution culture, where we're all conditioned to be extremely adversarial? And if you think so, if you think yes, then how do you think the youth particularly since India has the highest number of youngest population in the globe. How do you think the youth can slowly change this understanding of dispute and move towards more use of mediation?
So, like any other field, whether you talk about politics or for that matter, any significant change that we are talking about, the youth obviously has a significant role to play because those are the years, the nascent years, and the mindset, the approach of the youth is what derives how we are progressing as a nation, or for that matter, how we are taking a stand in respect of a particular aspect. So, the dispute situation is no different. So we see disputes right from our childhood level, whether playing with another child in the creche, fighting for a toy. So it's as simple as that. Or for that matter, in our day-to-day living, for example, in a husband and wife, you are always negotiating. You are doing different forms of ADR. You are negotiating with your wife. So that is something which develops your skill set as to how you react to a particular dispute or a conflict situation. So therefore, the role of youth and how they perceive and how they approach a particular conflict or a dispute situation is very important. So in case we are able to inculcate that culture of bringing about an amicable resolution, and the dispute should be only as a last recourse and only in exceptional circumstances, that will go a long way in changing the entire dynamics how we perceive the dispute ecosystem, whether we talk about a two parties fighting in a litigation aggressively, or being willing to embrace some form of amicable resolution with the intervention of a conciliator or a mediator or an arbitrator. So that will also help in a long way, in the sense, like we always talk about overburdened courts and justice is being delayed and all that. So if one person is willing to compromise, and if one makes a cost benefit analysis of pursuing a litigation vis-a-vis comparing it with an amicable resolution, the amicable resolution will always weigh higher in terms of the benefit when you compare the cost as well. And the time taken, the harassment, so the list just goes on. So therefore, the youth can play a significant role starting from the early days. The culture of conflict resolution should be inculcated in our course curriculum right from school level, not even in law school, because it is something which is important not only as law students and lawyers, but also as responsible citizens. So that is something which can be embedded in the different forms of like the education system that we have right from the school level. And then of course it will only get better with better training and skills being given by competent and trained mediators or ADR specialists.
Yes, sir. Sir, so like you mentioned that we go through disputes from our childhood and various stages at life. Sir, I would like to introduce our new question. Is that, sir, what are your thoughts on the statement that dispute resolutions are life skills? Are there any experiences from your life, either professional or personal, that you'd like to share on how these various dispute resolution skills have benefited you?
So, as I said, in answer to the previous question, so it is something which is critical right from that it lays down the foundation, not with the intent of being better informed and making informed choices or decisions, but at the same time in dealing with real life situations. So that is something which is very critical. And if your mind is conditioned to think in a particular way and take rational and objective thinking, after all, we are often taught in law school that law is nothing but strong common sense. So if the conditioning and if the training of the mind happens in such a way and in such a way that we are more inclined towards amicable resolution or bringing about objective solutions by hearing people out, by taking into consideration the pros and cons of pursuing a conflict into a dispute situation or resolving and nipping it in the bud right at the inception. So these are things which these skills will help one to definitely make informed choices and also take rational decision and reasonable decision, whether in resolving one's own personal dispute situation or a conflict situation, or for that matter, when one person is facilitating a dispute resolution between two individuals or two parties or two segments. So that is something which is very critical. So therefore, these are life skills. And again, I would like to reiterate that this is not limited to a law student or a lawyer. Of course, as a disputes lawyer, in so far as how it has helped me is definitely you get a new perspective. And as a disputes lawyer, you are supposed to be a jack of all trades, and like you get a better vision of how you perceive things around you. So you, as a doctor or as an engineer, without undermining any of the profession, what I would like to say is that you focus in a single-minded way. For example, if a person is a software engineer, so the person thinks in a particular way. But as a lawyer, you also interact with different sections of the society. So that is a major plus point because you are dealing with an engineer, you are having a doctor as a client, you are having a multinational CEO as your client, you as a HNI as a client. You are interacting with multiple people in the legal team of a company. So that gives you that exposure and the added advantage of interacting with different segments of the society. So to that extent, I would say that as a lawyer, it gives you an edge, and no wonder we see all our freedom fighters, majority of them. So that's the live example where lawyers, most of the politicians, you find them to be lawyers because because they are in a better position to take an informed decision, whether it is for their own individual or for that matter a state or a country or for that matter any platform. So without undermining, again, I would say that without undermining any profession, it as a disputes lawyer, it always gives you an edge to view things in a better perspective and in a broader perspective, which always helps.
Yes, sir. Sir, and one question that I would like to ask, sir, is that now that you have mentioned that there are certain lawyers who kind of depend like earn their daily wages by going to the court and depend on court hearings, and certain lawyers are also kind of as a legal system as a whole are kind of conditioned in this adversarial mode. So do you anticipate that there'll be some sort of resistance from the legal fraternity towards a mediation or an arbitration, not arbitration, maybe towards mediation in which litigation is kind of avoided? So do you think there will be some resistance by such lawyers who practice in more towards a litigation and depend on court hearings?
So I'll just take my own example. Like when I started my career, I practiced as a general litigation practitioner, and the perception which I got about arbitration was, again, as I said, that it was secondary to litigation, and it is only for having high tea meetings at the client's expense, where there will be out of 2 hours, effective hearing would take place for maybe 10 minutes. So that perception has significantly changed now, as I said. So it is not that ADR modes are non-remunerative, or for that matter, it would like take away the share or the role of lawyers. But at the same time, that perception has to change. And but in India, typically the approach has always been that unless you are pushed, you would not adopt it. Like again, I will take the example of technology, adoption of virtual platforms for court hearings. Unless we were pushed because of the situation, we were not ready and willing to adopt it. Although, just for example, like the Calcutta High Court, which also has a bench for the Andaman and Nicobar Islands, I realized during this lockdown that the virtual platforms are available for hearing matters of Andaman Nicobar in the Calcutta High Court for last 7 years. But this was never, that was news to me. So it is not that we do not have the technology or we do not have the means, but only thing is that we are not willing to adopt that technology. So that is the difficulty. So now coming back to your question as regards the lawyers facing difficulty, I think that the role of a dispute lawyer continues to be significant, and irrespective of whether we are talking about mediation or conciliation, of course, the approach may vary from a lawyer to lawyer. Some lawyer may be pushing a client towards the litigation for their own agenda or their own interest. But at least personally, I always think that at the cost of revenue, losing revenue, and at the cost of an early settlement, but at the same time, I would say that amicable resolution is the best form of dispute resolution. I've said this in a few other webinars also, and it may sound controversial coming from a disputes lawyer, but at the same time, that's the harsh reality. Amicable resolution, there is absolutely no substitute when you make a cost benefit analysis to any other form of dispute resolution, and even if we are comparing it with mediation or arbitration. Now, coming back to mediation, unless we are forced upon, we won't adopt it. So therefore, Justice Sikri rightly said that it is high time that we have an Indian Mediation Act, because unless you codify and you statutorily or through judicial intervention you mandate things, people will be slow in adopting it. The same happened with arbitration. Unless we had the strictness which were embedded into the system by judicial pronouncements, the lawyers, or for that matter the litigants, will always be slow. So we have made some progress. Like I'll give you the example of the Companies Act introducing in 2013 various provisions where mediation can be referred to by the NCLT. The Consumer Protection Act recently, we have seen that. The Commercial Courts Act, particularly Section 12A, which mandates that in a commercial disputes, mandatory mediation before you pursue a litigation. Of course, there are loopholes. Even the proviso to Section 12A gives you an opportunity to file an urgency application and bypass the mediation process. But at least we have made some progress, and these codification will only go a long way with the court coming into the rescue and passing some really proactive judgments to promote different forms of ADR, particularly mediation.
Yes, sir. And sir, I would also like to ask you about. I think there is one. I think it's Section 89 in the Civil Procedure Code also mentions that the court, after the issues are framed, may may ask the parties to opt for mediation or arbitration. So, how effective is Section 89? And when the courts actually ask the parties to go to mediation at that point of the trial in which the issues are already framed, do they usually come up to an amicable settlement, or usually it fails because or due to the emotions and heated dispute between the parties?
See, in my experience, I have seen that the court facilitated or court initiated ADRs are much more effective as compared to ad hoc, as I said earlier also, that where there is a lot more seriousness between the parties, because they know as a matter of fact that in the event they are not honoring the reference of disputes to the, for example, a mediation center or to a independent mediator appointed by the court, then they have to go back to the same court. and the court may have a perception created in the mind of the judge that the matter is having this merit, or this party's case is much more meritorious. That applies to every case, but at the same time, when a court has initiated the mediation or a conciliation, there is often we see that there is a lot more seriousness, and most of the cases we have seen that those end up in a favorable outcome, and the disposal happens much faster. So, in fact, we have settled like commercial disputes between two sets of multinationals, wherein they were strongly into like US dollars. Crazy amount of US dollars was involved, and we could conciliate and arrive at a amicable settlement, and the matter could be disposed of. Similarly, another example I would give, wherein both parties, there were FIRs lodged, although it was in my view, again, a criminal color was given to a civil dispute and civil and commercial dispute, only with a view to arm twist. But in spite of that, that ego, if I may again use the word commercial ego, that never came in. And ultimately, when the matter was referred to a mediator by the Supreme Court, so at different levels the parties fought at different high courts, and then ultimately when the matter went to Supreme Court, the Supreme Court referred the parties to mediation, and with the intervention of the mediator, a multi-billion commercial dispute, which also had its initial stages seen FIRs against senior officials and senior management people. In spite of that, the matter could be amicably resolved without going into arbitration. So that way, with the court facilitated ADRs, it's definitely working. So therefore, all the more reasons, if we have it codified in different forms, it will only bring in like more seriousness in the minds of the people.
Yes, sir. So I think maybe codifying it and institutionalizing it would also help in
Yes,
gaining the trust of the people as well. Yes, sir. Uh,
that's right.
yes, sir. Sir, and I think our final question, sir. So, as most of our viewers are going to be mostly going to be law school students and law students who are looking forward to be a youth mediator or a dispute resolution lawyer. So, what tips would you give to law students who want to be mediators or dispute resolutions, and how can success be achieved in this field of law?
Yes, in fact, very relevant because these days, at least the fact that we are having this discussion, that goes a long way to show that it has the different forms of ADR mechanisms, particularly mediation, has adopted significance over time. But when we were studying in law school, or for that matter in school, definitely these questions were only confined to textbooks. Those were never discussed. So, in terms of approaching a matter or a conflict situation or a dispute, it's no different. I would rather again start off with where I like with the answer to my very first question, that one has to be very open-minded and flexible. One should not confine his or her own approach in a particular in a capped, cribbed or confined manner. So one has to be flexible, be open-minded, see what the client's objective is to achieve. And when we are talking about conflict situation, always try to look for an opportunity to amicably resolve, even if it means compromising on such things. For example, if you are talking about a commercial dispute, you have a claim amount of principal plus interest. See if you can compromise on the interest component. Factor, step into the shoes of the other party, take an objective decision, analyze the pros and cons of how much money you will be spending in pursuing the litigation, how much time you will be spending, how much of harassment it would cause. So these are factors which you weigh objectively, and then take a conscious decision as in terms of advising the client as to what is the best strategy forward. In spite of that, if the client is willing and ready to pursue a litigation for other reasons, whether to set a right precedent, or for that matter wants to keep the records in order, and wants to, many times they talk about giving the right signals to the market as to how we handle a dispute situation. Like for example, I'll give you an example of a trademark issue. most of the time you would see that after you obtain an injunction order in an infringement or a passing off suit, most of the matters get settled or are hotly contested. So then, if you are in the defending side, it would entirely depend on how you assess. Like if your mark or your label is deceptively similar, and that is not very difficult to find out. And if your intent was genuinely to pass off the goodwill of the other player, then you can always make a compromise in terms of making minor changes or tweaking your mark in such a way that it is not affecting the other party. So these are, but if other party takes it that I don't want to compromise because it's a question of my reputation and it's a question of my ego, then it just goes on and you fight it out and you like end up in the Supreme Court, maybe litigating for next 10 years, by which time the registration certificate of your trademark itself is due for renewal. So it's about that. So therefore, one has to be flexible, open-minded, and ready and willing to amicably resolve, and should not always look at commercial interest of your own. Because again, why I say that is that the perception of a disputes lawyer has to be that of a trusted advisor, because the trust that you build in with the client, that goes a long way. You may lose out on a few lakhs here and there in terms of revenue, but at the same time, the trust which you have been able to build up with the particular client will ensure that in the long run, in case of a dispute situation, they will not go to anybody else, and which is more valuable than any amount of money that you may have earned in a litigation.
Yes,
So
sir.
reputation is everything, is what I personally believe. Because in even in from our childhood days, we were taught that if character is lost, everything is lost. So from a lawyer's perspective, and particularly in the context of a disputes lawyer's perspective, where you are interacting more with the society at large, and unlike a corporate lawyer, where
Mm-hmm.
you are mostly confined to your own clients and you are not interacting as much. Here you are confined, you are interacting with the clients, you are interacting with court clerks, you are interacting with the seniors, you are interacting with the judges. So there are multi-dimensional approach you have to think. So in those cases, being a trusted advisor, the reputation that you build over the years, that is something which will count in the long run. So character is lost, everything is lost, as people we were taught. So that is something which I personally follow, and I think that that is something which is most important in building a relationship of a lifetime.
Yes. Definitely, sir. Thank you so much. These tips are incredibly helpful, and our viewers are gonna really enjoy and love this interview.
Thank
Yes,
you,
sir.
Shreyas. Thank you
Thank
for
you, sir.
having me, and
Thank
it
you.
was again a
I really,
pleasure and honor.
yes, sir. Sir,
And thank you, YCM.